Well, good morning, everyone, and welcome to the next edition of the Mediate.com Book Club. I am delighted today to have the two authors of, what did you just say, Benjamin? You were the Amazon #1 book in data science for how long?
Among new releases.
And among new releases, that's fantastic. The Legal Singularity is a very, very important book tracing the evolution of the law and how artificial intelligence in particular is going to transform it. We've got Benjamin and Abdi today to talk about the book. And, we often have an interviewer to ask questions. And I think very appropriately, I'm not sure whose idea it was, we're going to have ChatGPT play that role, at least initially this morning. So I'm really excited about this. This is going to be a really rich conversation. So why don't we kick it off? And Benjamin, I know you have ChatGPT all queued up there. So let's see. Let's see what question. But before you begin with that, I mean, do you have any comments? Welcome. Thank you. I'm glad to hear that the book is getting the reception that it's getting. Abdi, you're flying around all over the place talking about it. Benjamin, you told me that you started this book 4 years ago. And it's amazing the timing to think that you worked on that and released it now in the middle of the ChatGPT LL.M vortex. So kudos to the two of you. Hopefully you got a lot of early shares in the companies that you talk about, because you're going to be on a private island soon enough. So, but please, anything you'd like to say just to kick us off before we dive into ChatGPT?
Thanks, Colin. Yeah. So what I've done is I've set up ChatGPT here on my laptop. So I'm speaking to everybody on my desktop. I've got my laptop here, and we're going to have a back and forth with ChatGPT. And I've set it up so we've got a voice for ChatGPT. So it's going to be reading. I'll have the voice read the actual response from ChatGPT, and we'll see how it goes. It may be irritating. It may be fun. We'll find out. But I'm happy to get into it.
Have you ever done this before? Do you know what ChatGPT is going to come up with? Okay, good.
No.
That makes it more fun. If you're going to talk about how the promise that AI has for the future of the law, it's good that you throw yourself on the whims of the LLM and see, whatever the next word predictor throws out there. So, so Abdi, any things you'd like to say to kick us off before we go to ChatGPT?
No, other than to thank you for having us. We're really excited to talk about the book. We've been talking about it quite a bit, but every group has sort of every conversation is a different flavor. And so keen to hear from folks today about what interests you in the topic.
Oh, we're definitely going to hit you from the dispute resolution angle. So, okay. Benjamin, why don't you kick us off and see what ChatGPT...
I heard it. I haven't had a chance to read it yet.
Oh, okay. Let's see. Let me mute Danita here. Okay, fantastic. Please, Benjamin, kick us off.
Okay, so this is ChatGPT talking. This is me. We've got ChatGPT.
Thank you for the introductions. It's an honor to be speaking with both Professors Aidid and Alarie today about their enlightening new book, The Legal Singularity: How Artificial Intelligence Can Make Law Radically Better. Let's begin with an overarching theme of the book, the concept of the legal singularity. Could you elaborate on what you mean by this term, and how does it differ from the broader idea of the technological singularity? Is the legal singularity a subset of the latter, or does it stand as a separate and unique concept?
All right, good question. I kind of feel like there needs to be a name for her, but I don't know what it is. It can't be Alexa, but anyway, why don't you take that one? Who's going to kick us off?
I think Abdi should be doing most of the answering, because I'm going to be like transcribing into.
Oh, okay.
You're on the wheels of steel. Okay, sounds good.
You got the big mechanical assist. I'm here on an island by myself. Okay, well, thanks, Ben and ChatGPT, for the great question. So what is the legal singularity? The legal singularity is this future state where the law is going to be functionally complete, knowable, everywhere on demand. It's this basic idea that we're going to get to a place, because of the massive increase in computing power, because of us starting to leverage the technology for these legal purposes, we're going to get to a place where the uncertainty that's inherent in the law is resolved. So that means getting legal answers more quickly. That means perform a legal analysis more accurately. That means optimal dispute resolution and settlement. It's a future state that is possible in part because we're more capable of performing the tasks that we sort of do in this analog way today through these new data science techniques. And so what's interesting about this idea of the legal singularity is that we talk about the functional completeness of the law, the elimination of practical uncertainty. There's some things that are uncertain that are inherent in the law, right? We sometimes articulate legal rules as broad standards because we want to capture a whole range of different kinds of social activity under the rule. It's not necessarily going to resolve for that so that, we can sort of automate legal advice all the time. It's just that we're going to have the practical elimination of uncertainty. Now, why do we use the term singularity? A couple of reasons. One is that we're sort of inexorably on a path. We're trying to describe a trajectory. So because we've gone from previously performing legal research in this analog way to performing it in this digital way through these online platforms, and now we're able to use all of that as data and perform sort of functions atop it and glean insights using new techniques, we think that we're trending towards a direction of increased technologization of what we do. But there's also the sort of social, cultural, economic, political convergence around new technologies that's going to probably accelerate that in the very near future. And so we're describing a future state, but one that we sort of make the case for already unfolding, and some of the key components of it, like the advent of legal prediction, are already here today. What's really interesting is the conversations that Ben and I have been having with folks over the last 5 years have been, very often people having understandable questions about whether or not we could do half the things that we were saying technology can help us do. And then in March, when sort of the explosion of GPT happened and there were suddenly millions and millions of users who were curious about it, the tenor of the conversation shifted from, is this possible at all, or even denial about it being possible, to what do we do? Mm-hmm. So in many ways, Colin, you're right. The timing is crucial, but sort of every day becomes more crucial and vital to us sort of like preparing ourselves for this future state that we're saying is highly likely to come about.
Well, yeah, Ben.
Okay, so I think I got this. It's working away.
That's a compelling vision, Professor Aidid. To elaborate further on this, considering the diverse cultural, social, and ethical contexts across different countries and regions, how do you foresee the realization of this legal singularity on a global scale? Could the implementation of AI in law create a universally accepted standard, or might we see divergences based on regional factors and interpretations?
Wow. Okay. Let me start by zooming out a little bit and providing a little bit of background. Ben, you're on mute. Were you saying something there?
I was just like, that's crazy.
That's a really interesting direction to go in. Yeah.
Based on what you answered, like that's actually a really good question.
One thing Ben maybe didn't mention in the beginning is that Ben has a transcription tool that's recording what I'm saying, feeding it back to GPT, and GPT.
Oh my gosh, so cool. I love it.
So that's the next question. And I know the trigger words I said were, social, cultural, economic convergence. And so before answering that, let me zoom out a little bit. So what are we seeing happening right now that we think makes this idea of a legal singularity possible? So one component is the advent of legal prediction. Ben and I are professors here at the University of Toronto Faculty of Law. Where we were doing a lot of the work that led to this book is as colleagues at Blue Jay, which is a legal technology company based in Toronto that Ben is a co-founder of. I was the VP of legal there for a few years. And we built these tools that were able to predict how future courts were likely to rule in new legal situations. You describe the fact of your tax or employment case to the software. It quickly synthesizes all of the historical case law and rulings and statutory information and legislative information, and then gives you a prediction as to how a court would treat your case. Not just the prediction, but it also gives you all the information that it relied on. It gives you a bespoke explanatory memorandum and all these things. And so we were working away on this, and it was becoming more clear to us as we improve the technology that, wow, this is really a mechanism for us being able to get answers to thorny legal questions really, really quickly. And you can imagine sort of the logical extension of that. If you have a tax problem, you have an employment problem, you have a legal question related to IP, bankruptcy, the criminal law, anything that might sort of govern your day-to-day, you can get the makings of an answer much more quickly than is possible through our traditional techniques, like engaging in case law research. And so one element you're seeing is legal prediction. Then you're also seeing the use of these generative AI tools, which are engaging in some legal prediction, but they're also starting to perform tasks for us, like help to automate some of the drudge work involved in legal practice, everything from the administrivia of, you know, taking notes to drafting letters to getting you to a draft quickly of a legal filing. You see generative AI more capable of doing those things, right? And so now that you have those sort of building blocks, the question is, what's next? Now that we begin to deploy these across our profession, what are the various ways that this can be helpful? How can we start to identify the right division of labor between human and machine, so to speak, so that computers are doing some of the computing and we're doing the, you know, the advice giving, the strategy, the analysis, the creative dynamic work involved in lawyering. The closer that we get to the sort of optimal arrangement of those things, the more likely this legal singularity is. Now, what I'm describing is a deeply human enterprise. So law is a deeply human enterprise because we make the laws, we decide through successive cases how they're interpreted, we reform laws, we have conventions around how laws are thought of and considered and complied with. But the way that we also do our work day to day as lawyers, really, you know, we have all kinds of discretion to accept or reject and decide how much technology we want to use in our day-to-day. And so there's no moment at which there's going to be a snap of the fingers and then suddenly we're all, you know, AI-enabled lawyers. It's going to catch on in the same way that cultural phenomena, technological phenomena catch on, which is through irresistible, highly compelling economic case mixed with a favorable regulatory environment and a sort of embracing cultural attitude towards the tech. And so that is because that's such a sort of human and social dynamic. The idea of it happening in this coordinated global way is highly unlikely, right? What's much more likely is that you see sort of waves of this catching on in different places, depending on how amenable the profession is, how embracing and open the regulatory environment is, how sort of the legal profession does its work in these various areas, right? And the other component of it is, you know, laws are catching up to evolutions in technology too, right? So you're seeing in the European Union, you're seeing a little bit in Canada, you saw in the US some conversations around minimum standards for artificially intelligent tools. You see an AI Bill of Rights, the Science Technology Office of the White House is talking about. In Canada, we have a new privacy law that includes an addendum involving AI. In the European Union, they're a little bit ahead of us in that they're trying to contemplate how AI tools ought to look. And that's going to have an effect on the quality of the embrace and how the stuff catches on. And so there's to answer GPT's question really directly, the regional variances, the differences are going to make all the difference in the speed of the singularity coming about. But at the end of the day, the sort of midwife of this is technology, and technology catches on in ways that the law keeps up to, and not necessarily vice versa.
Okay, here we go.
Thank you for that detailed response. It's fascinating to learn about how these advanced technologies can be harnessed in the legal sector, and your work at Blue Jay is certainly pioneering in that respect.
Thank you.
Indeed, this transformation will likely be a gradual and region-specific process. Yet, the potential disparities in the application and adoption of AI in law across various jurisdictions could lead to unique challenges. With that in mind, how do you envision managing these disparities to ensure fairness and equality in global legal practices? Moreover, how do we safeguard against potential misuse of AI-powered legal systems, particularly in jurisdictions with less robust regulations?
Good question. I think there's two ways to think about fairness, and to think about sort of disparity in use of these tools. So one is to sort of account for technology's upside, right? So if you're able to technologize a lot of lawyerly work, that is, and when I say the kind of work the lawyers do here, I really mean, you know, harnessing computing power for better prediction, using generative AI to, say, get you to a draft more quickly, for example. That has a great equalizing possibility. So imagine that you're a solo practitioner, you're a lawyer that works on their own. Maybe you or have a storefront office and you represent people in the community. Well, if someone walks in and they have a complicated legal problem, that they say, you know, I think I've been discriminated and I've been wrongfully discriminated against at work and I was terminated. I want to pursue a case. Can you tell me what my, what my options are, right? You're going to do a lot of things in that moment. You might shoot from the hip and provide some legal advice. You might want to hear more from the client. You might say you'll get back to them, but there's no way that there's no way in which you're going to not do some additional research. You're probably going to confirm your instincts by reviewing case law, checking against past precedent, even maybe looking into your old case files. Well, that same, in that same case, imagine the employer going to their firm who might have dozens of associates and saying, it looks like we have a lawsuit coming down the pipeline from an employee who thinks that they're being wrongfully discriminated against. Can you help us prepare? Well, the advantage there is that you have associates like I used to be spending hours and hours conducting legal research and producing fancy, well-vetted memos and using state-of-the-art tools. And so when eventually it comes to a point and there's a dispute, there's already been, I almost want to say, one side has already expended significant resources just preparing, and the other side is constrained, of course, by not just the lack of resources, but also their human limit on how many cases they can read in a day, right? And if you have a tool that allows you to at least get to an answer much more quickly by providing you with a sense of how the case might go based on the historic case law, and that tool is sensitive to all of the cases that have been decided in the area, not just the number that you can read. It's not just a sampling, it's a synthesis of the entire universe of case law. Then you start with at least the same place as the better resourced set of lawyers do. And so that's a great equalizing effect. And that's actually already possible and happening today, right, for those kinds of tools. So there's a way in which the technology can have this equalizing effect and can sort of correct for some of the resource disparities that exist. Now, that is, of course, assuming that technology is produced and becomes available in a way that those kinds of lawyers can access. And what's happening right now is that you see subscription-based models to legal technology tools, which is a great thing because they don't require the same amount of expenses on the companies that, say, the conventional legal publishers require. So for instance, if you were a lawyer who was doing your work in the 1960s, and let's say you're a New York-based criminal defense lawyer, well, if you want to conduct legal research, if you're not using the library system or what's available in the courthouses, you're buying these huge leather-bound volumes that are of case reporters that are costing you a lot of money. This is in the pre-Westlaw and Lexis and Bloomberg and whatever else days. You're actually limited by how many of those you can afford or how many you can access through either favors or through the public means. And that problem can be all but eliminated right now, right? So there's a way in which fairness, there's a great fairness dividend that can be paid here. When it comes to the inherent fairness in the tools, this is something that we've talked about pretty extensively in the book, where we say, look, misdevelopment of any technology is possible. In fact, it's especially possible in an environment where people are zealous about the economic upside of tools. So for example, technologists building predictor tools that, say, aren't attentive to equity considerations or aren't sensitive to the context in which they're being deployed. We talk about an example of a company that tried to develop a predictor tool that was supposed to assess refugee populations to identify which ones were going to be security risks or which ones were going to be likely terrorists, right? Like that's an example of you're entering into a fraught territory, and your excitement about the possibilities of the tech are making you, potentially engage in a massive misstep that has dire consequences for people. So the only solution to that kind of thing, because regulation's unlikely to do it, the only solution to that kind of thing is us sort of recognizing that we all have a role to play in technology's development, and it's not just a role for technologists to take up. So we give the example of this well-known case in Arkansas, where the Legal Aid Society of Arkansas filed a suit against the state. The state used to have nurses acting as bureaucrats who would make determinations about who was entitled to a personal support worker. So if you're someone who had mobility issues, you had the option of potentially a state-funded personal support worker to help you get around the house and whatever else, attend to your medical needs. And they switched out these nurses for an algorithmic tool. And the algorithmic tool, like all algorithmic tools, asked a series of questions to the users and said things like, do you have mobility issues? And then it would drill down deeper and say, do you have foot pain, right? And force people into a binary yes or no choice. Well, quite a lot of people were answering no, which would, of course, lead them in the direction of not being eligible for a personal support worker. But among the people that were answering no were people who were para or quadriplegic, people who were amputees, because they don't technically have foot pain, right? They were answering no, and then they were finding themselves much more likely to be denied a personal support worker, even though they obviously had mobility issues, right? So you're looking at that and you're saying, wow, like algorithms, like how could they, you know, they're backdoor austerity measures, or they're just ways for us to continue to eliminate people from accessing their needs. Well, I look at that and I say, number one, there's an issue of algorithmic design there. There's a problem of like a poor design choice. Like, don't force people into a binary yes or no choice. At the very least, you could have a free text option or a not available, or account for more information. But the other piece of it is the nurses who were involved in making the determinations in advance would have spotted that issue in a second, right? They would have said that this is, you know, if they had interviewed the person in person, they would have said, this is obviously someone who has mobility issues. But if they had reviewed the questionnaires, they would have said, this is going to force people into a choice that is going to, you know, include them in a category for which they're unlikely to receive the kind of care that they need. And so the answer to these things is, don't just cede the development of these algorithmic assessment tools to technologists or AI specialists or data scientists or engineers. Let's all sort of play our role. Let's start to have more human-centered design. Let's bring the skills that people have to bear on the development of these tools in a way that takes advantage of their skills and isn't just shortcutting technologically. And so there's all kinds of examples that we talk about in the book of the kind of work that we need to do to intervene and ensure that this doesn't become a runaway train. But I think the massive growth in public interest around these issues really bodes well for that, because the public is not going to be able to stomach tools that continue to do this, and they're going to be happening in more plain sight now that there's this widespread public attention. And so,
okay, Abdi, that was long, and so I submitted the response like halfway through, and then you ended up talking about a bunch of stuff that is going to be somewhat responsive. So listen to what ChatGPT has.
I'll cut to the chase
for that insightful response. It's indeed compelling to consider how AI technologies could democratize legal services, particularly for smaller practices and traditionally underrepresented clients. Switching gears slightly, I'm interested to know how you see the role of legal education evolving in light of these changes. How should law schools adapt their curriculum and teaching methods to prepare future lawyers for this AI-driven legal landscape? What skills and knowledge will be critical for lawyers to navigate this impending legal singularity effectively?
This is really good. I actually believe that lawyers, the legal profession, we take a little bit too dim a view of ourselves when we worry too much about technology supplanting us. First and foremost, lawyers, people in the legal profession have much more to offer than the technology currently does, right? So there's a lot of lawyers who say things like, is a tool like GPT going to replace me? Well, you know, it might be able to do some things, right? But think about why you went to law school. Think about why you became a lawyer. You didn't, you know, dream of spending every waking hour in the, you know, legal database universe, trying to find the exact right case, or you didn't dream of spending every waking hour conducting contract review, which is what technology is good at. What you really wanted to do was provide strategic value to your clients, problem solve, be a courtroom advocate, right? Provide business judgment to your clients. Those are the things you really wanted to do. And so there's a way in which if you focus on automating some of the drudge work, you free up time to be more creative and dynamic for yourself, which I think is a great potential benefit. And so actually our legal skills and the things that we are sort of trained for, I think can be actually on greater display, because whenever you hear law students complain about their legal education not syncing up with what they do out in practice, they're not saying that you didn't teach me legal reasoning. They're not saying that you didn't teach me the art of argument. They're not saying you didn't teach me how to be a wide-ranging dynamic thinker so that I could problem solve. They're saying things like, I didn't learn how to use this tool that I'm being used as a first year. I never did engaged in meaningful contract review. I never learned how to do due diligence. And that stuff I think is going to be more and more automated. And so we're going to start seeing, I think, some of the model of legal education a little bit vindicated, but here's where it needs to change significantly. We need to recognize the difference in the practice context that we're in. So for instance, we ought to be teaching our students how to be really effective prompters of technology. So for example, a tool like GPT, any large language model, the results that you get from it are highly dependent on the quality of information you provide it and the nature of the question that you ask it. Ben is getting good responses from GPT, probably better responses than I typically get from GPT because he asks better questions than I do, right? And so you look at that and you say, we could teach lawyers effective prompt engineering, and that's like a new skill. Or you could say, this is a way for us to refine the skill that we ought to have been teaching students anyway. Aren't we as lawyers supposed to be good questioners? Isn't it kind of the same thing that lawyers do with their clients or their witnesses? They ask questions in a way that's supposed to elicit the best information so that they can move forward. And so I actually think there's a way in which teaching students a prompt engineering for large language models actually is a two birds of one stone kind of pedagogical thing, because not only can you make them more effective elicitors of information from a tool like GPT, but also just it's a way for us to get back to deconstructing the art of the question in some ways. So there's things like that, and identifying what the sort of immediate skills are is going to be a bit of a tall order, because law schools have been doing things the same way for as long as they've been in existence. We often talk about imagine yourself being transported back to a law school in the 19th century. Not much would be different from the way that we teach law right now. There might be a screen up at the front, and students might have laptops on their tables. But for the most part, we're doing the same thing, the Langdellian sort of like case method, where we're reading treatises and we're reading cases and trying to identify the information. I think some of that has to adapt to modern times. I will say, and I know GPT is probably getting bored of me here. I will say that the sort of open embrace of the available tools is probably step one. Why? Because think about what our role is as educators. If a tool like GPT is going to improve the worst memo, let's say you have a class, you have students, 15 students who are writing a class assignment, the assignment is a torts memo. A tool like GPT might improve the weakest student. It might not do that much for the best student in terms of end quality, except to get them to a draft faster. And it might provide some improvement around the margins for the so-called middle of the pack. You could look at that and say, students are getting an unfair edge. Or you could say, isn't our role as educators to leave people better off than they came in? Isn't it to raise the floor? And if the tools do that, then we shouldn't be afraid of them. Physics was able to survive the calculator. And so I think we ought to be unintimidated.
Well, I'm tempted to take the reins back from ChatGPT, Benjamin. I'm sure you have another question queued up there. Abdi, is funny you just said, I bet ChatGPT is getting bored with me. It's like, that's the beauty of ChatGPT. She never gets bored. She'll do this all night. She'll do this until you pass out. But Benjamin, do you have another question queued? Do you want to do that?
There is one, and we'll end it with this one.
Okay, let's do that.
Yeah.
That's a brilliant perspective, professors. It's indeed about harnessing the power of AI to elevate the human elements of law, allowing lawyers to focus more on client representation and less on the drudgery. In the light of the increasing significance of AI in the legal profession, ethical considerations naturally come into focus. How do you see the role of ethics evolving in the context of the legal singularity? Specifically, how should we address the ethical dilemmas that could potentially arise from the use of AI in law, and how can law schools effectively prepare future lawyers to grapple with these issues?
Yeah, I'll try to keep this one quick. I think it's really, we have a chapter in the book where we talk about sort of the ethics of AI use in law and law adjacent fields. And one thing that we urge people to do, and it's really important that observers of AI do this, is to start to distinguish between which ethical issues are actually about the technology and which ones are not. So there's a certain kind of ethical problem that people point to, let's say underlying bias in algorithms, or racist or sexist outputs of predictive tools. And there's a way in which I think sometimes focus on those as technological problems when they're really what we describe as reflection and amplification problems. So, garbage in, garbage out, right? If there's bad historical data, then a predictive tool that's based on that historical data and little else is going to project that negative history into the future. And so if you're trying to, it's no surprise that in Florida, when they were trying to use an algorithmic assessment tool to determine things like bail conditions or someone's release conditions after a conviction, that they were finding it to have inequitable outcomes along racial lines, because that's the sort of history of prosecution in Florida, right? They're using that data. We talk in the book about if the FHA was sort of using their own historical data to decide which mortgages to insure and back, then it would have to account for its history of redlining. So if it did nothing else, just project that stuff in the future, you'd have African Americans structurally precluded from accessing future loans. And so that is a social problem. That's a problem of our history and who we are. That's not exactly a technological problem. You could provide safeguards and find ways to tamp down some of the concerns, but I don't want to take us off the hook for like being less racist and less sexist and, just better, right? Like don't over focus on the technology piece of it to take you off the hook of the difficult social work that we have to do together. And that's one of the themes of this book is we kind of have to land the plane of AI, and the way to do that is not just to tinker on the margins of what the tech can do. It's also to engage in sort of the difficult and concerted sort of social conversation around these things. The technological problems, the ones that do require us to tinker and alter and create conditions and parameters, that stuff I think is we're on a good path to getting better at those things. You see the conversations around hallucinations with ChatGPT right now, and all the work being done to try to root those out. That stuff, it takes care of itself a little bit more than the social consequence stuff does. And so I just want us to remember, we still have to live with each other, and we still have to relate to one another and exist in a community. And so don't just focus on the tech. Let's also be better.
Wow, man, there's so much to chew on here. I think this is fantastic. So Ben, you were very patient there and just sort of administering ChatGPT. I can't believe you sat on your hands through all of that. Do you have any thoughts or reactions that you want to contribute along these lines?
Oh, I spent so much time chatting with Abdi about these things, and in the course of producing the book, a lot of what Abdi's said is the result of many hours of conversation and back and forth about this. And maybe I'll just turn to the last part that Abdi was talking about. This is something that when Abdi explains the conclusion that no, these are problems that exist in the real world, and we shouldn't just relegate them to a technology box and say, oh, these are algorithms of oppression or something. It's like, that's a very powerful line, and it's a powerful way of thinking about the challenges of reflection and amplification that Abdi was talking about. But it's so powerful that it can actually be counterproductive and take us away from all of the work that we really need to be doing in the law. And so I think Abdi and I were back and forth so much in the production of that chapter in particular, and trying to think this through and how do we talk about it, because it's a delicate point to make, because of course technology can make things worse if you just uncritically rely on it. You don't take those objections seriously. On the other hand, we shouldn't allow those objections to have so much more force that they take us away from, the really meaty principal issue, which is, there are lots of problems in our societies that we need to address. And so it sounds obvious when you say it, but it wasn't at all obvious to us. And I remember sitting in my driveway in the car, because Abdi and I were having a chat about this chapter, and I just sat there, continued to sit there in the car, and we talked for, I don't know, another 45 minutes or an hour, because we were getting into all of this. And I think that's when we finally cracked it, Abdi, in that conversation a few years ago.
Yeah.
And then we knew the direction we needed to take the chapter in the book on that. So it's tricky. It sounds obvious when Abdi points it out that way, but it really was the result of a lot of thinking.
Colin, I just want to say one other thing, which is a real life conversation I had with a judge, where the judge was expressing some skepticism. It's a trial court judge who was really skeptical of the idea of using technology for any decision making. And part of what they said was, I just don't know what goes into a lot of this stuff. And I'm like, would you feel better if we told you? Like, if we just showed you everything that goes into it, would you feel better? And the judge was like, yeah. And I was like, by the way, I don't know anything about you. I don't know how you were raised.
That's it. That's exactly right. Yeah.
I don't know what's going on at home. I don't know what you ate for breakfast. I don't know how you feel about me, right?
Yeah.
And part of what I was getting, I was putting some extra sauce on it, right? But part of what I was trying to get across to them was the problems that you're pointing to that exist in technology are valid.
Absolutely.
But they also totally exist in our traditional analog world, right? And the only thing that Ben and I are trying to point out is not that the problems don't exist. It's that they exist across the board, and our sort of like social and our entire response to it has to be one that recognizes that and doesn't place the onus only on technologists to provide technological solutions, because those might be unsatisfying.
Sure.
Right?
Sure.
And so let's actually do the hard work, and then let's change the laws that aren't serving us. That's
Absolutely.
another point.
Well, I think it's a great springboard into the next portion of the conversation here. One of the things that's interesting. So first of all, I agree with you 100%. You're talking to an audience of mediators and arbitrators here, people who have built dispute resolution systems. And we traditionally talk about what we do as ADR, alternative dispute resolution. Well, an alternative to what? We're an alternative to the legal system, an alternative to the judicial model. That particular evaluative-based, precedent-based model for resolving disputes, we spend a lot of time coming up with other ways to resolve disputes. So one thing that frustrates me, and you're going to also, this crowd, I know because these are friends, are very, very sympathetic to what you just said, Abdi. We're constantly being evaluated against the ideal of the law as opposed to the reality of the law. And I know 90% of the questions you're going to get in your book talks and your responses with bar associations and judges and law schools, people are they're going to push back. And they're going to say, what about this? What about that? They're going to identify all these potential vulnerabilities in it. But again, they're not comparing this new legal singularity against the reality of the law in the past. We know in the United States from decades of research that people of color get 30% worse outcomes than white people. This has been established, and it's not fundamentally changed over time. And as you say, Abdi, when you're talking to this judge, like, I don't know what goes into this. It's like, well, you know what? You don't know what goes into the face-to-face either. I mean, who knows what biases are harbored by the people in the system? And if you try and go and put your finger on where that bias enters into the process, it's very difficult to find, because it's not in any of the civil code. It's in all of the individuals who are running the system. So I think comparing what's coming, the legal singularity, to the reality of the vast majority of these cases are pro se cases, and people who are unrepresented get worse outcomes. The system is a monopoly. The legal system is a monopoly. It's controlled by, I won't say a cabal because that's a negative word. I'm a non-lawyer mediator, so I'm going to try and avoid whatever biases I can project onto the law. But it is very controlled by the bar associations. If you don't like the process or the service you're getting from a court, you can't go to another court. There's no competitive pressure. So there are a lot of shortcomings in the current design of the system. And I think we in the dispute resolution field, we have a blank page. We can say, Abdi, if you and I have a dispute, we can say, let's play a game of checkers, and whoever wins, gets the money in question. We can design whatever dispute resolution process we want, because we're defined by what we're not. We're not the legal system. Now, we can build a private judging process and we can hire X judges and we can go through every stage of the court process, but we can administer that in a JAMS or a AAA office, and that's slightly different because, we're just tinkering around some of the things we don't like within the judicial model, but we can still, maintain all the trappings of it. Or we can just do a direct negotiation or mediation or restorative justice process, which looks entirely different than the court process. So the other thing that I found about, it's great when ChatGPT is asking these questions. I think it's hilarious that they do a little bit of these social lubricants. That was a brilliant answer, professors. This is an incredible contribution. The work you did at Blue Jay, it doesn't know anything about Blue Jay. All it's doing is predicting what the next word in the sequence is, but it's got us figured out to a T. It knows exactly what things we need to say, wow, ChatGPT, boy, that's really great. It's doing some great, but the thing that's interesting is it sweetens everything, right? And if you look at OpenAI and you look at what a lot of these manufacturers are doing, like Claude and some of these socially responsible AIs, they want to take out the hate, they want to take out the recrimination, they want it to all be peace, love, and understanding, which is great, which I think is they need to put those guardrails in place for AI to have the legitimacy that it needs to have in order to get inroads into wider society. But the reality, Abdi, and I think you spoke to this, inside our hearts, we're not all peace, love, and understanding. We have a lot of war, hate, and stereotyping. And the reality is, I think that AI, the encroachment of AI, particularly when it's coded with these guardrails to focus only on sort of the sunny side of life, I think it's going to make people a little bit more, unpredictable. And it's going to make us a little bit more, so when I ask questions, I don't want to sound like ChatGPT. If you didn't have ChatGPT, I'd thrown you a couple softballs because, you want to be nice. But now I'm tempted to be, hey, let's be more combative because ChatGPT kind of just, laid it all out like a pat of butter on a hot griddle.
Yeah,
so I don't know. What do you think about that?
That's really, Ben, I find that to be really interesting.
I'm super curious, Colin, what it would look like for you to bring it.
Bring it. Yeah. Okay. Well, no, let me give you a little bit of the non-lawyer mediator. Okay. And I'm just going to put this out there and I want you to react. I don't want to hijack this because this is your book. Now, the singularity, the original word of the singularity is the center of a black hole, right? It's where there's an infinite density and nothing escapes. Now, I know that the reason why you use legal singularity is not that usage. It's more the information singularity, right? And people who've talked about that, like Kurzweil and others over the last 50 years, they're talking about the emergence of a super intelligence. Okay, so this notion that we're going to have a moment where a computer processor exceeds the power of the human brain. And that's what Kurzweil talks about. He talks about it happening sometime in the 2030s. But now we're talking about what if the computers understand, if these AIs understand the world on a level of sophistication that so far exceeds our ability to comprehend the world, that objectively we know that they can do a better job. As you said, Abdi, they can read 2 million articles in 20 different languages and come back and render a decision that in milliseconds is more sophisticated than anything that a human can render. So let me just go back to, I feel like you're both law professors, and I mean that in a lovely way because many of my friends are law professors, but are you thinking only about the ramifications of the emergence of this superintelligence within the frame of the law? Because I guess I would say, if we have a superintelligence out there, do we need the law? Okay. And I say this as someone, I'm a descendant of Oliver Wendell Holmes. So I'm not a lawyer, but I've read a lot of Holmes. And Holmes talks a lot about the path of the law and what is the law and why does the law work the way that it works. The law was designed the way that it was designed because it was powered by people, right? Powered by judges, powered by lawyers, powered by juries. And now if we have a superintelligence that can consume all of this information, why are we even considering deploying this superintelligence through the same mechanisms that was not created for superintelligence? It was created for legal systems in little communities. I mean, it's bound by geography. We have all these little laws all around the world. The Toronto has a different law than Quebec, which has a different law than Calgary. Why? Why would we need that if we have a superintelligence? So I guess the first question I'll ask you is, why does this need to be a legal singularity? Why can't we come up, and again, if we have a blank piece of paper and we have these tools at our disposal, can we design something better that's optimized for the usage of these new tools in our hands? Are we merely paving the cow paths of the legal system by using technology to make it marginally more efficient, when in fact the framing of how disputes should be resolved should be fundamentally reconsidered? All right, how's that? I'm trying to bring it here.
Love it.
ChatGPT would not ask that question, by the way. So yes.
Well, I don't know. Maybe if we kept going.
Maybe.
I think you're exactly right. This is one of my favorite books. So I know we're supposed to be talking about the legal singularity, but this is one of my favorite books by
Great.
Nick Bostrom, who's a philosopher in the United Kingdom. And this book is terrific. Nick talks about, all the different ways that we might realize a different superintelligence and what, runaway intelligence and intelligence explosion might look like. And then the challenges that we're very likely to confront in trying to make sure that superintelligence is compatible with our desires as humans. And, we could, like, in chatting with Nick Bostrom in the past, he's made the point that, how much thought do we give to an ant colony that may be on a vacant lot before we decide we're going to pave over that vacant lot and put in a parking lot? We don't give it a second thought. We don't know what the preferences of a superintelligence might be, but they may not necessarily care so much about the preferences of humans.
Mhm.
And so this raises big existential questions for us, Colin. And so if you want to go deeper on superintelligence, I would totally recommend.
Well, and we can get philosophical here, and I think we need to keep it in the realm of the four square of the law and dispute resolution. But I do think there are some very interesting questions. We are going to be setting the guardrails for how these superintelligence deploy in the realm of dispute resolution and the law. And, so hopefully we're not going to create AGI and it's going to say, well, we like the ants better than you and there's more ants, so we're going to go with the ants, no more parking lots.
There's something to this idea of the consent of the governed, Colin, right? So if you have a superintelligence, it is capable potentially of creating, a superior legal response than any single individual, technology assisted or not, could ever produce on their own. I still think there's something to this idea of the consent of the governed, and you need the governed to agree that this is the mechanism by which we're going to be governed. And I think a just legal system requires the consent of the governed.
Yeah,
now,
Ben, I want to put my finger on that. Yeah, because in dispute resolution, that's an animating principle is choice, know, and in the law, you have a lot less choice than we have in dispute resolution, right? If you're going to negotiate media, you control the outcome. You decide if you're going to participate in these processes. You pick your neutral. In the courts, that doesn't work, right? If somebody files a case against you, you got to show up. And if you don't show up, you may end up in jail or you may have a giant penalty. So this notion of choice, I think, is an important one. I personally think we need to build I think there needs to be a flowering of 1,000 different channels for resolving disputes. And I think if we get it right with AI, I think people are going to make the choice to go have an AI resolve their dispute because they're objectively going to look at the options available to them through the judicial process and say, this is better. It's faster. It's more consistent. It's fairer. Let's go the algorithmic route. But, I know there are others who disagree with that. They think that the province of the judiciary needs to be public because if you just create private entities or nonprofits, who knows what values they have. And they may use the judicial system to impose their preferred order on the world.
Abdi and I have a colleague here at the law school, Mariana Prado, who's written a lot about institutional bypasses and their role in improving governance, particularly in developed countries. So thinking about economic development and the quality of law and institutions and development. And it's so interesting because, Colin, earlier you described the state bar associations and the courts as quasi-monopolies or monopolies. And, the best way to actually improve the fitness of an institution is to produce a viable alternative.
Absolutely.
They're going to have to hit the treadmill. They're going to have to start working out. They're going to have to start.
And that's the Silicon Valley orientation is disruption, right?
Or
we need to
everything,
disrupt the system.
Yeah. Or it's creative destruction, right? And,
I also, I was in the Peace Corps in Eritrea. I have many friends in Eritrea, and the Eritrean justice system is a mess. No one wants to resolve. The judicial system in that country is part of the government's essentially lockdown and control of the population. And 50% of the people around the world have no meaningful access to a judicial system. So already we have a world where half the population on the planet doesn't have access to fast and fair redress. Okay. So by using technology to reinforce, in a sense, that model, are we going to be able to expand access to justice another 5%, another 6%? Or can we think of a radical notion, a radical rethinking of the way that we can deliver justice to people that's decentralized, where it's not relying on the power of the state, it's not relying on any public entity, anybody has access to this, and code becomes the law. So then we can put these super intelligences out there. You don't have to worry about your jurisdiction. It doesn't matter that you're Eritrean or you're United States or from China. You can go get access to redress in one of these channels, and maybe it has integrated enforcement, So that's
Yeah,
a notion where the state has no role in the future of justice.
yeah,
Please.
Colin, that's fantastic. I was gonna say the key piece of this is the integrated enforcement. Like there's I was listening to you talk about this idea that it would be great if there was all these competitive channels, and right now there's a monopoly in the courts effectively are the only place where you can. And I'm listening to that and I'm like, you know what? In many ways, people do kind of consider the courts one of many dispute resolution options.
They do.
So the other options that they have are not very good. And I'm not talking about mediation here. I'm talking about the average person who might not know mediation is a thing. They still think of many different dispute resolution channels. They say I could go to court, or I could capitulate. I could work it out physically.
Or I could call the 1-800 number for American Airlines.
For American Airlines. I could, I could find some other grievance mechanism. I could, grin and bear it and complain to my spouse about it. Like there's all these different ways that we sort of get the energy generated by disputes off of us. And the courts are just one place where we do that. And so the question is, what options can we make the other options better? And one of the things that I think is more likely to happen, because we're talking to courts, we're hearing from judges, we're talking to people that are in government agencies responsible for this and various departments of justice, and they're talking about incorporating more of these tools kind of as triage, where you get. In Ontario, in Canada, we have something called mandatory mediation, right? It's only in a few cities, pilot program, where for all kinds of civil disputes, you first have to demonstrate you've exhausted an ADR channel of some kind, right? Now, imagine that there was actually a sort of like stepladder kind of process where you have to start this way, or you start by submitting claims to an AI, and the tool identifies which ones for which there is actual factual dispute that it can itself resolve. And that stuff gets referred to courts. You might look at that and you say, that seems like it's the right division of responsibility, because if most of the things are garden variety disputes for which there's no meaningful factual or legal disagreement, and it's just about having a binding resolution, then maybe we can have the mechanical assist for those kinds.
Right.
And then the thorny kinds of issues, the ones that maybe have second order social, political, economic implications,
right,
the ones that go to the dignitary interest involved in maybe those
fundamental rights. Well, that's Neil makes that point in the chat too. He talks about we can use these predictive models for things like IP taxation, technology disputes, but when you get to like constitutional law, criminal law, when you talk about rights, you talk about the values that undergird the society. The law is an extension of that, and maybe we need to reserve those disputes. That's the province of people. But a lot of this low-hanging fruit, high volume, low dollar value civil cases, that's fine. Let's automate it. There's no value. It's not like we're generating jurisprudence on the back of debt collection disputes, But as long as we're ensuring that those algorithms are operating within our value frameworks.
We are, though. That's the thing. We are generating. These garden variety disputes about, say, debt collection.
Yeah.
The steady accretion of these kinds of cases ends up articulating a judicial philosophy.
It does.
It might counsel. That might be sort of maybe bad for the indebted, or a little bit too easy on the debt collectors, which maybe should be in a different business, right? And so this is the path of the law, the steady accretion of judicial decisions which make our common law. And so we ought to be paying attention to the garden variety disputes, and there's a way in which we can have a better record of it all if we could start to think about ways to use technology. As for the criminal law, family law, the fundamental rights piece of it, again, it starts by an honest accounting of our status quo, right? So how are people currently, how are their interests currently being served in the world of family law and criminal law? I can give you a stat from Ontario, and here something like 53%, I might have the number, it's in the 50s, of middle-class people that start a family law dispute. These are divorce and child custody kinds of cases. Start with a lawyer and end without one. Right. And this is the middle class. So forget people who are, and these are among the most existential kinds of disputes. These are the ones involving custody of your children and sort of what's going to happen to your marriage, right? And people are going at it alone. They're going at it alone completely in civil cases at a much higher clip. In criminal cases, there's a legislative backstop often to people going at it alone in the form of here we have the legal aid system, the voucher system. In the US, of course, you have the purported guarantee of a criminal defense lawyer if you're accused of a crime. But what's interesting in those cases is the question of what actually about this representation, about a criminal defense representation, what parts of it actually need to be done by a person, right? So the work of strategizing about whether someone should take a plea deal, reading the mood of a judge, helping the client think through what their life is going to be like. You know, they're often going through some of the worst moment of their entire lives and requires a sympathetic ear. That's the proper positioning of the lawyer. Is it though necessarily the drafting of the brief or the evaluation of the expert testimony or the legal research? Like that stuff can still be done. As far as the courts are concerned, why can't we have a similar task by task approach where we say, for certain things, computing power is more appropriate. But for the key things, the ones that maybe go to their fundamental rights, like the determination about what evidence to exclude, the determination about credibility of a witness, maybe those things are the ones that we reserve for judges. But the case management, right? The review of the underlying case law in a file.
Well, that administrative stuff is the low-hanging fruit, and people are very comfortable with algorithms taking that. But again, I'm trying to be challenging here. Are lawyers necessary after the legal singularity? If we can have a super intelligence that can go out and look at all these factors and come back and provide that advice, there's a counseling element, but I'm wondering how much do lawyers actually do that? Are there alternate players in the system, coaches or mediators or something like that, that can maybe do a counselor that could do a better job than the legal model, where, you know, you have, again, there's a lot of perverse incentives also in the legal representation model. So, you know, I understand why lawyers are threatened by some of this, because, you know, there are a lot of lawyers that get paid a lot of money on an hourly basis for the knowledge inside their head. And this super intelligence, this coming in super intelligence, is going to have more knowledge inside its quote unquote head. So they're going to have to change the role that they play. I'm not saying that it's unnecessary, but it's definitely going to alter their role within the resolution process. And I could do this for hours. I'm so sad that we're running out of time. But let me just throw it open and see, does anybody have any comments or questions they'd like to share with our visiting authors before we get to the end of the session here? Claire, I do see you recommended the Thunderhead series, looking 75 years past a superintelligence taking over. I got to go buy that. I haven't read that. That looks amazing.
It's so good.
Okay.
It's so good. It's simple to read, but it's whoever, I forget the name of the person who wrote it right now, but I think they had a crystal ball, because everything that they've been describing is exactly on track with what's coming true. Yeah.
Well, that's what I love about sci-fi. All of this stuff that was so crazy when I'm a kid, it's like, well, this is now daily reality. So,
I know,
you know, I read Neuromancer. I'm like, this is cool. And now I'm like, I think I'm living Neuromancer. So, Ismail, do you or Neil, do you have any comments? Oh, please, Claire, did you have something?
Yeah, to go with what you were saying about, are lawyers necessary? I think especially in relationship disputes, anything that's a value, anything that's heart related, absolutely. But I think all of the e-commerce stuff that we've been talking about, where my emotions aren't wrapped up into it, absolutely, let's let a super intelligence take over. I think it's only when there are those emotions and feelings involved that, yes, we can have technology handle 99% of the case management, the scheduling, the invoicing, all of it. But I still think when the heart's involved, you still need that split second where there's another person looking at you saying, I see where you're coming from.
But is that the role of a lawyer, or could we have a better role? Can we change the role of that assistant in the process to be, I mean, I think a counselor or a psychologist might do a better job in some circumstances.
You might be right.
Ismail, did you have something you wanted to say?
Yeah, you know, this has been wonderful talk, and I wish we had more time, but just quickly, you know, among many questions that I have, I wanted to ask Abdi and Ben, standing in the future 5 years from now, how do you see the courtroom?
Ben?
I mean, this is the hardest time period. So, I mean, if you had asked where's this all this go in 50 years, I think we'd say, you know, things are going to be radically different, and they're going to be radically better. And probably, you know, it's going to be unrecognizable. We'll just take for granted legal certainty. We'll all have the equivalent of like a personal legal agent that we can interact with that'll give us like perfect advice and kind of take us through things, and like it'll be very seamless, and it'll be like, can you believe in the past people didn't have this technology? And it'll be like us trying to think about a pre-electrification kind of age. Like, how would you actually have survived? Like you didn't have electricity, you didn't have plumbing, you didn't have books. Like, how is it that, how did people survive? I think so that's the far future. That's easier than the question you asked. The other easier question, time frame, is like, what's happening in the next 12 months to 18 months? Like, okay, well, we're going to see, further developments along the lines that we've seen them recently. We're going to see more predictive legal technology. We're going to see improved online dispute resolution. It's going to increasingly be influenced by artificial intelligence. We're going to see parties like do research. Like this 5 to 10 year block is really, really tricky, because I don't know how the politics are going to play out and how the institutions are going to combat the technology. I think we could, like, if we were just talking about just the straight exponential technology curve, things are going to be radically possible that are not possible today. So technologically, tons of things are going to be possible. The question I have is, I don't know politically how our institutions are going to fare. I don't know how bumpy the road is going to be ahead. I don't know how much these feelings that we need to slow things down, we need to stop this progress, how effective those are going to be in the battle for hearts and minds of people who are often feeling like the legal system isn't meeting a lot of their needs well. And so it's going to be a political contest about how this plays out in the medium term, which is what I've described, that 5 to 10 year period. So you asked the hardest question possible to end, which is, where does this go 5 to 10 years from now?
Well, the good news about future prediction is nobody ever comes back and holds you accountable. So you can say whatever you want. I think it's a safe bet to say that our grandkids are going to look back on us as like cavemen, because they're going to have the LL.M straight into their brains, and they're going to think, wow, gosh, those poor people kind of just sloshing around in that human mess. But Abdi, why don't you wrap us up here and bring us home?
Yeah, the one thing I want to say is, I want to encourage everyone, especially who have expertise in dispute resolution mediation, think about getting in touch with the folks that are thinking about how to design technology and actually sharing your expertise. It's just really, really important. We can continue to talk to each other, and we should, but we should also start to have the cross-sectoral interdisciplinary conversation, because you'd be surprised by the kinds of mistakes that are possible without folks like you in the room that are able to sort of guide the process. You have a sense of what disputants want and need. You have experience that is not always, some of the experience that escapes the data that technologists are looking at. And so get active, like start thinking about ways that you can meaningfully contribute, because as Ben described, that 5 to 10 year period that we're about to embark on, it's going to be a bumpy road full of potentially contradictions. One thing you're probably about to see in courts, and you're starting to see this, is courts issuing practice directions, asking the litigants to identify any area of their filing that's been generated by a tool like GPT, which is, if you think about it, that's kind of pointless, because they're not asking you to identify any area which was written by an intern or a summer associate or an associate in the office or a junior lawyer, but they're asking you to, and so do you underline everything that spell check looked over? Do you only circle the stuff GPT wrote? What about if you paraphrased it, right? We're going to be entering that period of contradiction, potential overreaction, but also radical embrace in some other areas. And so it's not going to look like a linear trajectory, but the thing is, we're still very much in like day zero in the grand scheme. Right. And so get involved now, get active, really start to talk to people and think about ways that you can bring the expertise of mediators and arbitrators to bear on what's being developed, because mediation arbitration is one of the first spaces that you're going to see the state-of-the-art tools being built for and deployed, because you don't have the same rules. You don't have the same rules that are going to prevent it from happening. You don't have the single buyer problem of government.
That's right. And we can move a lot faster than the judiciary. So yeah, it's already happening. Yeah. Wow, Abdi, I want to take your class. That talk there jazzed me up. I want to go be a 1L now.
Well, I teach ADR. I teach upper year ADR, and so it'd be
okay, great. So you're one of us, baby. All right, look, this was fantastic. This was a great conversation. The two of you are on the front lines of this. Thank you for the seeds we plant today are the forests of tomorrow. So you're going out there and you're having these hard conversations. But I thought this was a fantastic. I'm really, really sad it's over, and we're even 6 minutes over. So I appreciate your indulgence. Can we please get a round of applause for our visitors? Thank you. Thank you so much. Virtual applause, little animated hand clapping. So thank you very much. Stay tuned. I know we're going to do a book club event on Claire's new book soon, and that's going to be wonderful. So thank you, everyone. Have a great weekend. And thank you to Ben and Abdi for spending time with us today.